prosecution's expert or witness will be allowed to attend, as well as Dr. Ruvo would still listen to Dr. Edelman. I think that would expedite the process.
Thank you.
That's accurate, Judge. Generally, there is an exclusion for expert witnesses. In part, that's the reason for the stipulation. The state's witness is going to be a fact witness, but nonetheless, the defense is not objecting to him being present.
All right, thank you for addressing that. That does streamline things. All right, Mr. Burt, just want to call your
Dr.
witness.
Edelman. Did you get him? Your Honor, there was one other issue I wanted to raise with the court. When the court made its ruling on the 13th, opening this hearing to the public, I believe, if I'm not mistaken, that the court reserved the issue of whether particular parts of the hearing would need to be closed. And there are certain slides, video presentations, that when we get to those, I will be asking the court to take them in camera, explaining why I think so, and we just, for the record, ask the court for a ruling.
Thank you. I appreciate that heads up.
Sure.
Doctor, if you wouldn't mind coming forward, standing right here to be sworn in. Sure, go ahead. Well, either way. You're just going to stand right here to be sworn in, and then we'll have you come to the stand.
You do solemnly swear that the testimony you are about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Now you can sit over there.
All right, so if you'd like to get seated, make yourself comfortable. Looks like you brought your own water bottle, but generally we have water bottles. So go ahead and get situated, and then bring that microphone close to you. Sure. We just want to make sure that the audio record picks you up, so
Okay.
if you could do that, I appreciate it.
I feel so tiny in this chair.
All right, Mr. Burt.
Thank you. Tell us your name and tell the court what you do for a living.
Sure. My name is Brian Edelman, and I am a trial consultant based out of California.
And what is your educational background?
I have a PhD in social psychology and then an LLM in international law.
What does a trial consultant do?
So as a trial consultant, I work more with attorneys and counties and other clients, more as an advocate, I would say. And I do pretrial research such as focus groups, mock trials. I help with jury selection, so write juror questionnaires, oral voir dire questions, attend jury selections, give recommendations in terms of cause challenges, peremptory challenges, a lot of post-trial interviews after trials are over, so post-verdict interviews. And I also work as an expert, which is different hat. So when I'm doing this type of work, it's more as an objective person, so I'm not advocating for one side or the other. So that's a different role.
What were you asked to do in this case?
Can you speak in, I'm sorry.
Sure. What were you asked to do in this case?
So at this point, what I was asked to do was to assess whether or not people in the community are being exposed to media coverage, how closely they're following it, and what their sources are. So not a change of venue survey. A lot of the work I do isn't change of venue. I would not classify this as a change of venue study.
Okay. There's a binder there in front of you. Would you take a look at tab 1, please?
Sure.
Is that your resume?
It is.
And does it set forth all the cases you've worked on, either change of venue or doing community surveys, the kind that you were asked to do in this case?
Yeah, for the most part. I mean, I'm probably, not all of them are in here, but yeah, these are most of them.
All right. Now, did you prepare a PowerPoint
I
for
did.
this case? And is that in tab 3 there in front of you in the binder?
Let's see. Yes,
And I've informed you we have some time restrictions here, right?
yes.
You think you're going to be able to get through this whole?
I'm going to talk really fast. I've had a lot of coffee, so I think it will be good.
Okay, good. So if I could bring that up.
All right.
Okay. So why don't you walk us through what you were asked to, or what you're going to present here in your
Yeah,
presentation?
so I'm not going to talk about the social science literature, just because Dr. Riva is going to do that. But primarily we'll focus on the extent and nature of the coverage in this case. And this isn't a change of venue study, so it's really focusing on what coverage has come out of these hearings, more of from the video streaming and video cameras in the courtroom. So not looking at an analysis of the prejudicial nature of the coverage per se, like we would in a change of venue survey. And then the second part is the survey that was done to see what impact this has had on the jury pool. Are people following it? What are they seeing? And what impressions they have at this point. So I would consider this like the baseline. This is the floor of where we're at right now, and we'll see what happens moving forward. And then the last section, if we have time, talks about some of the challenges cases like this pose when you're trying to pick a jury in a community like this.
Great. So you said on the first area, the social science literature, that's something Dr. Rubis going to talk about, but did you have one key point you wanted to make there?
The only thing I want to say about it, because we'll touch on it when we get into the media coverage, is, there's a lot of research on this, and the main takeaway I want to talk about is the types of pretrial publicity that are most prejudicial is emotional pretrial publicity and pretrial publicity around the character of the defendant. So all I'm going to say is, because it'll come up later.
Okay. So I'm going to skip ahead
Okay.
to the extent of the coverage, and has the coverage impacted the jury pool?
Right, okay. So again, this is just looking at two things. Where are we at today in terms of the extent and nature of some of the coverage, focusing on the question of whether or not having cameras in the courtroom is potentially prejudicial, and if it's creating sensational content, or is it more of a neutral nature that, people watching live streams and things like that? And then what impact has this coverage had so far on the jury pool?
And question 2 is answered by your survey?
By telephone survey, yes.
All right. So let's take a look at the first area, the media coverage.
Okay, so I just wanted to touch on the extent of the coverage. So the data here come from two different sources. The first source is called Newsbank, and that's an archive of newspaper coverage. So when it's looking at the coverage in the state of Utah, there's 831 articles in that Newsbank that are sources that are based in the state. And it's probably a conservative number because it's not exhaustive. There's things that are missed. But I'd rather be conservative than overly inclusive.
Right.
And then Utah County, 697, and I believe it looked at like 15 sources primarily, 15 newspapers. It also includes Fox KSTU, the local Fox station, and there's 209 news segments that are in that archive. The last section there, that row, is from a Lexis search, which is different, and it captures transcripts. So there's 441 of those that are nationwide, but it is limited. So it doesn't include Fox News, it doesn't include, I think, MSNBC, NBC, so it's not an exhaustive list. It's only certain.
I'm sorry, it includes CNN, the major
It has
networks.
CNN, I think it has CBS, NBC, or maybe ABC or something like that, but it's missing some of the networks.
And I told the court that on his thumb drive, or on his drive that we provided, was the 441 transcripts,
Okay.
6,000 pages.
Yeah, that's right.
You've seen that?
I have seen that.
Okay. Next, I think you're going to look at the nature of the media coverage, and what was the framework you used to do that?
Yeah, so one thing I wanted to touch on is, this is the American Bar Association rule, so 3.6 about pretrial publicity. It's not the rule, whatever the Utah one, this is just the ABA. And the thing that stood out to me initially is, when we talk about people who work in, attorneys, people involved in the case, like what they should and shouldn't introduce to the public. And one of those things that are key factors to me are extrajudicial statements that the lawyer knows or reasonably should know, will be disseminated by means of public communications and have a substantial likelihood of materially prejudicing the adjudicative proceeding in the matter. So anything that's particularly prejudicial in nature, you shouldn't be releasing if you know it's going to lead to bias. Examples when we talk about the defendant, when I mentioned defendant character evidence is particularly prejudicial, we have character, credibility, reputation, or criminal record. And then tests and things like confessions, admissions, statements given by a defendant. When we talk about tests, it could be DNA, ballistics, things like that. And then opinions as to the guilt or innocence of the defendant. And then anything they know might be admissible. So this is the stuff I look at. Are things crossing that line? Because those things are particularly prejudicial, and I think the ABA, a lot of that is driven by the research that tells us that.
Okay. We're on slide 14. What does this show us?
So the reason I point this out is because a lot of the prejudicial content that's come out so far that you see in the media and keeps being reproduced on social media, in television newscasts, is what was initially released in this press conference. So, it was the indictment or arrest affidavit, and there's a lot of prejudicial details that are distributed in there where it's, a very long press conference. We're literally reading text messages from the defendant to his roommate, and they're prejudicial. They imply there's some degree of guilt in there, and it's reading it, the whole thing, which is then disseminated, and it gets reproduced on TV and reproduced again and again and again. It appears in social media posts, reels on YouTube, and a host of other places.
And does that reproduction include when the coverage relates to in-court appearances?
It does. So, we'll get to that, but the information that was here keeps getting reproduced in a sensational way on TV. And not only that, like here, he's reading it, but when you see it in the graphics, it shows text message that implies this is the actual text message on a phone that came from the defendant, and it's not. So it's very prejudicial and misleading.
So you say on your slide this serves as sort of a megaphone and a distributor of certain information.
Yes, and
is within the categories you set out.
Yes, and when it's being distributed, just to point out, it's not like it's only distributed on conservative media outlets like Fox. It's on CNN, NBC, all of the networks. So it's widely being distributed to all types of viewers.
And in terms of other sources of this megaphone effect, your next, and by the way, you've got the actual video of the press conference.
Yeah, this is a clip of it.
We're not going to play that
Yeah.
because of time limitations, but it's
Right.
there if the court wants to look at it. Are there other sort of megaphone factors here?
Yeah, so this is a unique factor in this case in the sense that people who are very influential, obviously the President of the United States, or former Attorney General, these are people that have a lot of influence and power, perceived credibility, and they're making strong prejudicial inflammatory statements, and I think that's unique. I don't usually see that in cases. And calling for the public execution of the defendant before there's been a trial, things like that are unique in nature.
All right, Your Honor, this is one of the slides I would like the court to see, and it's, as he just indicated, expressing opinions, strong opinions about whether Mr. Robinson should be executed. So if the court wants to take it in public, that's fine, but for the record, I'm asking the court not to do that. I do think it's important that the court hear this, just the tone of it, and the substance, I think, is very important for the court to consider. Since we are submitting it, the PowerPoint is on the drive. The court could listen to it outside of the public domain, however the court wants to proceed.
So I'll make note of that, and I'm happy to review that in its
Thank you.
entirety.
If we're not going to play, just one thing that's unique about it, if we're not playing it, is
Sure.
there's inflammatory language in there that also creates in-group, out-group identification. When I think,
Could you explain that?
yeah, so it's like a lot of people identify with a political side. Unfortunately, I'm a member of the Democratic Party or Republican Party. I'm liberal. I'm conservative. So I think there's some language in that clip where it mentions, I don't remember the exact phrase, but something about like lunatic leftists or something like that are doing this. So it creates this the outgroup is dangerous, they're lunatics, maniacs, or whatever phrase was used, which creates more of danger, the perception that members of that group, that outgroup, are dangerous and there's a danger there. So that's something that comes up later as well.
And how is that kind of information more or less prejudicial?
Well, it creates, again, in-group, out-group identification, and we think members of the out-group are not like us. They tend to, they're all the same. We attribute stereotypes that, of how those people behave. They're more likely to impact how we see them. You're less likely to have empathy for members of the out-group when group salience is high. Versus members of our group we see as individuals, or complex, less likely to be impacted by stereotypes, more likely to empathize with them, identify with them, things like that.
All right. Now, did you actually take a look at the court appearances that have so far taken place in this case to see what was discussed so that you could compare what was happening in court with what the electronic media was reporting was happening?
In terms of the comparison of what's happening and what's being produced?
Yes.
Yeah, I did look at that.
So the timeline, could you explain this, what you have up here?
So this is just a timeline of the hearings that have taken place and like high level what they were. So like the initial WebEx appearance, pretty brief, and you would think that's a pretty neutral, not very significant hearing, and you would expect if you're looking at the media, it should be neutral. It shouldn't be highly prejudicial, inflammatory, since very little happened there, right? Mm-hmm. And the same thing when you have like the waiver hearing, appointment of counsel. There's not a lot of fireworks. It's not the preliminary hearing. No evidence is being laid out or anything like that. So you would expect the media not to be introducing prejudicial content, given the nature of those particular hearings.
If they were serving an educational function.
If they were educational, transparent, a summary of what occurred, these are very procedural, technical things, are not necessarily sensational in any way.
So did you take a look at the first hearing, the initial WebEx appearance by Mr. Robinson? Right.
So this is a brief, short hearing where, I think he appeared on WebEx, right? And then I looked primarily at what did that elicit? What was the reaction to the media? Was it kind of just summarizing this is what happened, or was it more sensational in nature?
Okay. So let's take a look at the clip. And this is from NBC News.
You have been watching that court
on that
hearing
date,
for
correct?
the man suspected of shooting and killing Charlie Kirk last week on a campus in Utah. You saw the suspected assassin, 22-year-old Tyler Robinson, there not speak.
I think we got a problem with the audio.
To thank all parties for being here, and this concludes to thank all parties for being here.
Well, I need to... Let me check and see. That's in settings.
Is this source, the volume for the source might allow for amplified volume.
Oh, yeah, right, okay. That's what, all right. Let me unplug this and replug it. That's the way it happened last time. Speaker. It's not coming up. By the laptop. Okay, we can do that. Okay. Okay, so is this first slide from... It's not in there? All right, let's try that out.
There we go.
There we go. Okay, let me escape. Okay,
Did you skip the previous,
so let me go back.
19? There you go.
There we go. So is this, as you indicate on the slide here, this is ABC's coverage of the September 16th, 2025 WebEx appearance?
Yes.
And in this clip, are you picking up the coverage right after the court says we're in recess?
Yes.
Okay. I don't know what's going on. Frustrating. No, it's not. Getting no audio at all.
Want to try a different laptop?
I'd have you reboot that laptop first before you try to get one.
The week. I'm sorry.
I recommend rebooting the laptop.
Okay. Try that. Apologies to the court. Thought we had this set up. Let's do. No, I've rebooted.
Pull the cable out one more time, and then plug it back.
Say again?
Pull that HDMI cable out now that you're doing that. And plug it back in.
That work?
There we go.
There we go. Okay. Yes. I think we're good. Okay. My apologies. So you're picking this up from the point in time right after they've shown the whole hearing?
Yes.
And this is kind of the aftermath?
Right.
You have been watching that court hearing for the man suspected of shooting and killing Charlie Kirk last week on a campus in Utah. You saw the suspected assassin, 22-year-old Tyler Robinson there, not speaking, wearing what appeared to be some kind of green vest, as the judge read out the 7 charges against him, including, of course, aggravated murder. The state making clear that they are seeking the death penalty and putting in place, the judge did, a protective order, apparently at the request of the state, for Erika Kirk, Charlie Kirk's widow. I want to bring in Danny Savalos. I want to bring back Steve Patterson, who's live for us in Utah. Danny, here too, some of the paperwork is just into us on that protective order that the court finds the defendant represents a credible threat to the physical safety of that person here being Erika Kirk. Danny, stand by for a second. I want to go back to Steve Patterson here. And Steve, it has been a remarkable series of developments over the course of the last several hours as state officials, the Utah attorney there earlier in the day described, and the charging documents, some of these probable cause documents showed step by step, almost minute by minute in some instances, how they closed in on this 22-year-old as their suspect.
They did, and in doing so, we got the TikTok, we got the charges, also these, the exchange of text messages between Robinson and his roommate. These are details that we simply didn't have before. One thing that sort of gels with what we saw in the text messages, this exchange again before and after between Robinson and a roommate who believed to be romantically linked, is how cognizant and lucid Robinson appears. And I would say that for looking at this video, although unblinking, so unblinking and eerily at times that it almost appears like the video is frozen. Just want to comment a little bit more on the physical appearance of Robinson, appearing over WebEx on video. Appears to be wearing what is described to me as a safety smock. We know he's on a special hold, right? They're going to hold him there in a separate unit before they evaluate his mental health, before they put him in maybe a more different location, a more general location. They do that as a matter of procedure, right? But it is sort of interesting. He did say one thing, which was his name, which was stated clearly and firmly. And again, I want to say gels with sort of what we saw in that exchange of text messages, because he's talking to his roommate who clearly appears to have no idea, the roommate, what is going on or that he is the suspected shooter. And yet he's sort of talking a TikTok of what he's done and why he's done it and admitting to do it, essentially shocking this roommate through these series of exchanges, which sort of gels with his physical appearance today. Obviously, we also heard during the hearing the Utah County following the course of action to introduced the death penalty as well. That was filed as this was being read in court. So definitely some developments here today. And just the amount of information that we got, the blanks that were filled in.
That's right.
Not only that, but also on the apprehension, the involvement of the mother as well, and sort of bringing him in. And also the physical evidence, the DNA found on the actual trigger of the rifle, which was tied to not only what was found on the screwdriver, but also the towel used to wrap the rifle. So an extraordinary amount of information that we got, especially with this charging document that's now in.
What's also clear from these text exchanges laid out, Steve, is that Robinson had no intention of being caught. And I say that because he said he had hoped to to die of old age with this being his secret, according to what the state had laid out in this text exchange. Almost seemed panicked when describing trying to go back to return to retrieve the rifle that he allegedly shot Charlie Kirk with, not being able to do so when essentially caught out by his parents, when his parents approached him and said, you know, we think this may have been you, tried to get in touch with him, tried to reach out. The state says that Robinson suggested or implied that he may try to take his own life here. So you can get a sense of his mindset, at least based on some of these text exchanges and what law enforcement has laid out over the course of some of these documents here. All of it, as we should note, these are the state charges here. It's possible federal charges could come.
Yeah, federal charges possible. One notable sort of omission is we didn't see any federal officials. We don't know if federal charges will be filed, although it's heavily implied that they will. You know, one thing also is sort of the level of deceit, both with the parents. The father did something that sounded very clever. It was heard the description of the rifle that had been described by authorities, federal authorities, state authorities, and that he assumed, you know, obviously with the pictures of Robinson himself on camera at the university, assuming this is his son, trying to get in contact with his son, trying to ask, hey, could you send me a picture of the rifle that I gave you? And of course, the son sort of ghosting him, seeming to imply, again, involvement. And also about the rifle, there was a lot of investigative work to try to figure out, was the rifle traceable? Was it bought legally, illegally? Would have been hard to trace, we now know, because this was essentially a family heirloom, something that's common in hunting families, passed down from grandfather to father to son, and that was the case here. So again, much more stark relief that we're seeing this case in Hallie.
That's right. Robinson also telling his mother he had been out sick, had stayed home sick over the course of the 2 days that she had inquired about. Steve, I know you're going to stand by for us later on as we get potentially more on this. Danielle, let me go back to you here briefly because Steve laid out what could come next here. Obviously, the death penalty that the state is seeking. What about this protective order for Erika Kirk? Is that something that is typical in the course of an investigation like this, a prosecution like this?
Sure, yes. As to prospective victims, it's usually not entered against someone's spouse, but it makes sense here because this is not some street crime or a crime of passion. This is someone who was apparently, whether by this defendant or not, targeted, and so it makes sense to say, well, close members of the family may also be targeted as well. So it's not unusual for judges to enter those kinds of protective orders as sua sponte on their own or in response to a request from the prosecution.
Danny Savalos, thank you very much for that. I appreciate that. We have been talking now about the developing news that has occurred over the course of the last several hours, with prosecutors laying out in detail how they say Tyler Robinson carried out this murder. We're going to play a big portion of that in case you missed it earlier. We want to basically roll that tape so you can hear for yourself how the state laid this out. Take a listen.
These are the allegations.
And let me stop it right here. At this point, does she play essentially the entire press conference by Mr. Gray?
Yes.
Okay. And we didn't include the entire 27, 30, or 45 minutes, right? We clipped it to get to the end of the coverage.
On September 10th, 2025, at approximately 12:23 p.m., Charlie Kirk was shot and killed while speaking to a large crowd on the campus of Utah Valley University in Orem, Utah. Police found the suspected murder weapon, a bolt-action .30-06 rifle, nearby. Over the next approximately 33 hours, police conducted a manhunt for the shooter until the evening of September 11th, 2025, when Tyler James Robinson surrendered to police at the Washington County Sheriff's Office.
You have been listening to Jeff Gray, the Utah County Attorney, earlier laying out those minute-by-minute details on how they caught the man accused of assassinating Charlie Kirk. You saw the court hearing for suspect Tyler Robinson live before that. That was that virtual hearing. As prosecutors say, they will seek the death penalty. Robinson will remain in jail, no possibility of bail. He'll be in court again in just about 2 weeks.
And again, just to reiterate, we cut 27 minutes out of the press conference, right?
Yes.
So how does this coverage line up with what was happening in court?
Well, I think, like we said, there's an implication that there was, like, the text messages were part of the court hearings, because he implies that was part of the hearing, And then it's bringing up all of this new information or old information that has nothing to do with the hearing. So it's just rehashing. Let's remind you about the text messages, DNA, the deceit of the dad because he was suspicious of him in terms of the gun, and all of these things have nothing to do with this hearing.
I noticed the reporter, when he put that graphic up of the text, by the way, was that graphic the actual phone of Mr. Robinson?
It's not. No, and it implies, and you see that throughout a lot of the coverage, like text messages. There's YouTube reels where somebody like creates a reel and reproduces text messaging so it looks like it's the real text message.
And when he's putting that up there, he says, as we heard in the hearing, words to that effect.
Yes.
But there was no mention in the hearing of text messages or anything else, was there?
Correct.
Is he confusing what he heard in the press conference with what he thought he heard in the hearing?
Well, I think he's confusing the viewers with what happened in terms of now that, there's a belief like evidence is being presented in these hearings that imply guilt when that's just not the case.
So as you say in your slide, is this coverage sort of advancing the prosecution narrative as opposed to an educational function?
Yes.
All right. Did you also take a look at ABC's coverage?
Yes.
And by the way, the last slide was, I think, the longest slide, right?
I think so.
All right. So this is the same day.
To thank all parties for being here, and this concludes this hearing. At this time, court is in recess.
So the suspected shooter there of Charlie Kirk, the hearing has now just concluded. We know that the state is pursuing the death penalty here. We have just learned throughout this proceeding that they are going to try to find him counsel. They deemed he is indigent, so they will be providing an attorney for the alleged shooter, and the next time that he will make a court appearance will be September 29th. And then again, as you heard the judge there say, that will happen on WebEx. A couple other things that we learned here throughout this quick hearing is that he will remain in custody without bail, and that the state was also present there, and they asked for a protective order on behalf of Erika Kirk. Of course, that is Charlie Kirk's wife. A reminder to everybody that, yes, he was a conservative activist, but he was also a young husband and a young father of 2 children, and a protective order has been granted on behalf of Erika Kirk. I do want to bring in our ABC News Chief National Correspondent, Matt Gutman. He's in Spanish Fork, Utah, there for us. Matt, thank you here for being here with us. And so we just saw this proceeding play out. No surprise, right? This is not the proceeding in which this person would enter a plea. But Matt, prior to this, there was a lot of evidence that the prosecution sort of laid out for the public, including text messages, DNA, things like that they do plan to try to present to the judge to be admitted here in trial. But perhaps, Matt, you can just gauge for us, since you've been covering this now for so long. Tell me about your first reaction here in seeing Tyler Robinson sit down there, if you were able to see it, sitting down in this court hearing.
He was sitting down. It was via WebEx, so he wasn't physically in the courtroom, Kana, with the judge. But you could see that people were watching. You could see he was wearing this padded vest, and that's because he's been in what's called special watch in this jail here, which is essentially an isolation. He's being held to prevent him from harming himself or from others harming him. We heard from the prosecutor earlier today in his announcement of the charges that the suspect's mother had said that he was suicidal and that he wanted to kill himself allegedly instead of turning himself in. So you see him in that protective garb. The bulk of this hearing that we just saw was the judge reading the 7 charges. Of course, they are aggravated by the fact that the suspect allegedly committed this political assassination of Charlie Kirk in full view of children. So that's one of the things that has enhanced the charges against them, and one of the things that makes this a capital case, according to prosecutors here.
And I'm hoping we can just quickly go through some of those text messages that you mentioned there, again, with this roommate with who prosecutors say that he was romantically involved with. And one thing they touched on in this hearing, too, Matt, is the fact that in this text message exchange, we're showing some of it, but Matt, they pointed out to the fact that they believe the shooter asked his roommate to delete the exchange and then to not speak with the media, and then it's shown in these charging documents, Matt.
Yeah, we have not seen these text messages. We have heard them for the first time from the prosecutor. They also put out this charging document in which these messages were revealed, and it appears to show this exchange between the suspect and his roommate, with whom he was romantically involved, apparently, and it's very, very detailed. And in the text messages, the prosecutor says that the suspect was talking about the murder weapon, talking about where he stashed it, talking about how he stashed it, and yes, allegedly advising his roommate to delete the messages and not to cooperate with law enforcement, to get a lawyer and not talk to the media if this blows up, and eventually it did. What also struck me about these messages, at least initially, is that the suspect appeared to think that he could get away with this. He was hoping that he would never have to mention this to anyone ever again, and that they would never be able to find him. And it was only, as we've learned through these text messages presented by the prosecutor, when he realizes that he can't get back to that rifle that he stashed and take it somewhere else, and he realizes that police is right in that vicinity and he can't go get it, that he is in trouble. And that's when things start to spiral out of control for the suspect, according to these text messages. And at that point, he does appear, at least afterwards, to talk about being suicidal, not wanting to turn himself in. Eventually, he's convinced by his parents that he should not do any harm to himself and that he should do the right thing and turn himself in.
Right, and the prosecution revealing this was his grandfather's rifle. It was a very important piece of family property.
Right.
Matt Gutman, thank you, as always, for being here with us today. I also want to bring in our ABC News, Washington, D.C. Bureau Managing Editor followers for more on this. And Catherine, again, no real surprises here in this initial court appearance. I think everyone now marking their calendars here with September 29th to see what kind of counsel this alleged shooter does get ahead of time. Also notable, again, a protective order has been granted on behalf of Erika Kirk, Charlie Kirk's wife, throughout this hearing. But Catherine, I think really the prosecution made a huge effort here to lay out as much of their case publicly as they could, and they made it very clear, Catherine, in this hearing that they are ready to give over all of this discovery to the defense. The state really making an effort to have their ducks in a row here ahead of this court appearance.
Yeah, exactly. You did hear them say that, all of that information that they've gathered, that we've heard about, obviously, through the press conference earlier, and these charging documents. There is a lot of evidence that they have. There's mountains of evidence that they have that we've learned through public documents like the one we received earlier, and also through our sourced reporting. We know they're doing forensics, for example, on the weapon that he used, which you just discussed a moment ago. So yes, they said that they're getting fascinating, Kana, to see him for the first time, from sitting there from jail. He stated his name in that clip that you're playing where you hear him talking. That was him stating his name, Tyler James Robinson. And I noticed at some points when the judge said, I'm looking at my notes, but when the judge said to him that he was going to remain in custody without bail, you could see Robinson shake his head yes. When he said that he was going to read the charges, remember there's seven counts here, 6 felony counts. When he told Robinson he was going to read the counts, you could see him shake his head a little bit of movement there, but he hasn't said really anything else, of course, other than stating his name, and he will be provided an attorney. But I do think that it is quite striking to hear and see all of that evidence that it appears that the prosecutors have gathered. Looking at the charging documents again, we, of course, have been really focusing on those text messages that Robinson and his roommate exchanged. It appears they exchanged on the 10th, so shortly after the shooting. Now, it's unclear whether these are all of the text messages in the possession of prosecutors. We don't believe so. There's probably more, but those were quite striking to see.
So how does that coverage stack up with educating the public about what was going on during the initial court appearance?
Well, I think you can see he's trying to, in the beginning, lay out what occurred, and she actually stops him and says, I want to get to the text messages, and brings it up again and moves it there, and implies, again, that stuff came out in the hearing. So it's kind of blended that sometimes it's mentioned in the charging documents, sometimes it's, the prosecution made an effort and implies in the hearing, again, in just focusing on the evidence. It's not focusing much, that's like a 5-minute clip, and there's very little about what happened. It does mention what happened. I don't want to act like they didn't talk about that at all, but they blend quite a bit of evidentiary information in there, and at the end of the day.
And when you say evidentiary information, are you talking about incriminating evidentiary information?
That has not been determined to be admissible or anything, so, right. It's just, here's the text messages, and calling it a mountain of evidence and all that kind of stuff.
Yeah. Okay.
To thank all parties for being here, and
But also, you
also
have a
look
very
at,
stoic,
How CNN was covering this initial appearance.
Yeah, this is the same hearing.
And your understanding is the person in the CNN clip is a former prosecutor who's CNN's chief, quote, legal analyst, right?
Yes, right.
Okay. Let's take a look at that one. That's your next clip, 24, I believe.
but also you have a very stoic defendant who I was looking to see any emotion that he might be displaying. Hearing that the death penalty may be requested for you is a very monumental, seismic moment. He had no reaction, nodding in essentially understanding alone. But then there was also a protective order that was asked for by the prosecution on behalf of Erika Kirk, now widow of Charlie Kirk, that entails that there might be an element of fear that she is experiencing, or the thought that she wants no contact, either from him or anyone around him, that would make her feel more secure. Of course, she was a mother of 2 young children. You understand that. But here you've got a speaking, essentially, indictment of sorts from the prosecutor earlier today, which laid out so much evidence. It's all allegations, the statements of counsel, not evidence in a court of law. But what can come in a court of law?
Yeah.
Statements of the defendant, including all these text messages.
So according to CNN in this clip, the evidence that she hasn't looked at is admissible, right?
And again mentions it was laid out today, implying that it was laid out in this hearing, and discusses his demeanor. He didn't react properly, according to her. His body language didn't, whatever the appropriate way to react is. So, focusing on him, focusing on these text messages, calling them admissible, without ever...
And I notice in all 3 of these nationally broadcast clips, there's a real focus on the protective order.
Mhm.
And tying that to Mrs. Kirk's fears, correct?
Yes.
How is that furthering the prosecution's narrative?
To me, it just goes to future dangerousness of impressions of the defendant. So we kind of talked about earlier, negative character evidence is prejudicial, and also we know from the research that pretrial publicity in fact affects verdicts and the perceived credibility of the defendant, likability, and sympathy. So it kind of goes to that.
Okay. Did you also look on that, for that court appearance, on what the local media was doing?
Yes.
Right. And before we turn to that, did you also look at how Fox 13 captioned the importance of the hearing on the 16th?
Right. So transcript reveals Robinson's alleged confession to shooting Kirk and messages to roommate with a screen capture of the court proceeding.
So the gist of what happened in court, according to Fox, is the confession?
That's what it implies, yes.
Yeah. Okay. Now, at the local level, did you look at this clip from...
Following Robinson's initial appearance in court today, we did speak with a body language expert who has been part of hundreds of high-profile criminal cases across the globe.
And some of the most compelling cases include Brian Koberger, Lori Vallow Daybell, Casey Anthony, Karen Reed, and Alec Baldwin, Scott Peterson, P. Diddy, Gypsy Rose Blanchard, Amber Heard, Prince Andrew, Nicholas Rossi, to prolific serial killers, Ted Bundy, John Wayne Gacy. Tonight, Chief Investigative Reporter Wendy Halloran talked to Scott Rouse, who helped break down Tyler Robinson's body language. Wendy.
Well, Jamie and Mark, Scott Rouse dissected the nonverbal cues, analyzing gestures, expressions, and demeanor after Robinson learned prosecutors will seek the death penalty against him in the assassination of Charlie Kirk.
Tyler James Robinson. Thank you for being here, Mr. Robinson. I'm Judge Graff.
Tyler Robinson appearing virtually from the Utah County Jail in a suicide robe.
It's really odd behavior for someone who should be stressed in that situation.
Scott Rouse is a world-renowned behavior analyst and body language expert. He holds multiple certificates in advanced interrogation training and has trained alongside the FBI, Secret Service, U.S. military intelligence, and the Department of Defense. He serves as an expert consultant for law enforcement and the U.S. military, among others.
I'm going to tell you from my experience what I see going on here.
I asked him to analyze Robinson's demeanor.
No big, deep breaths. We saw a couple of breaths that weren't deep breaths, but they were breaths from just, it looked like they were almost from boredom. So that was a little bit odd as well.
Rouse says when he looks at people in situations like this,
Things like this, I look for things that are missing, and those are all the things that are missing right out of the gate. And this is odd behavior for someone who theoretically should be fairly stressed at this point.
Rouse says it could be that he hasn't slept much.
Even though it doesn't look like a whole lot going on there, that's odd behavior for a situation like this. I've seen these 1,000 times where someone is being in the same situation, you're talking to them, and they've done something horrible. And they don't know what's going to happen next, they don't know what to expect, they don't know how to act during that. And this guy just looks relaxed.
Rouse recounted what facial expressions he would look for.
And you've got things called adapters where you try to get rid of built-up stress and tension. Don't see any of those. We see a little bit of clenching of the jaw, and his jaw goes over to his left. I think it's his left. And that's about it. In my opinion, he's pretty much resigned to whatever's going to happen is going to happen. There's nothing that tells us he's frustrated. There's nothing in his face from an expression perspective that tells us that he's worried or frustrated or angry or anything.
Rouse says there were no jerky, tense body movements, and he meticulously watched his eyes.
We can't see his blink rate very well. Blink rate tells us if someone is concerned or thinking about something or is stressed about something because your blink rate goes up a lot. Because the normal human will blink about 15, 20 times a minute. And from what I could tell, it was a low blink rate because I was catching maybe 10 times a minute. It wasn't a whole lot. So I think from an emotional standpoint, he's given up.
Now, Rouse said if Robinson was concerned about something, his eyebrows would raise. He says he didn't see that happen at all in this hearing. Mark?
All right, interesting. Wendy, thank you.
What stands out to you about this kind of coverage?
Well, now we're completely speculating with sensational conjecture because he didn't blink properly and his eyebrows didn't go up enough or whatever it is. And now it's creating this impression that this person has no emotion or empathy, like he might fit I think later it becomes a sociopath, and we all heard the story of they have no emotion and all that. And this is all based off of him watching a WebEx for a couple seconds and just making these ridiculous statements because he's the body language expert now. So he can now make an assessment from this hearing that he didn't respond properly because he's, quote, given up or whatever he said. And this is all, obviously, none of this is informative, and it's all speculation and sensationalism.
And by the way, you're aware of the fact that the court has moved the camera from the front of the courtroom to the back,
Yes.
right? And moving it to the back, does that still allow some room for these so-called body experts to maybe analyze how his shoulder was tilted?
If his jaw doesn't move
Right,
right,
sure.
or controlling if somebody turns around for a second, I mean, it's a courtroom. Things happen over time. So the fact that anytime there's a movement, it might spur some ridiculous story about somebody's nonverbal language is incorrect is personally, I think, is pretty sensational and ridiculous.
Okay.
Following Robinson's initial...
Now, did you also take a look at the September 29th hearing?
Yes.
And what was your understanding of what actually took place at that hearing?
So this was primarily, from what I remember, it was appointment of counsel in this hearing.
It's called a waiver hearing. You got on your slide, waiver hearing, appointment of counsel. And again, Mr. Robinson is appearing on WebEx at that hearing.
So it hasn't been in the courtroom yet, still
So
WebEx.
was it your understanding at that appearance, counsel got appointed?
Yes.
Essentially. All right. So how is that covered, first of all, by Court TV? And before I show you the slide, are you endorsing the criticism that Court TV in the slide makes against the court and the prosecutor?
I'm sorry, endorsing what?
Are you endorsing the criticism that in the slide of the court and the prosecutor?
No, that's just what was said by one of the commentators.
Were you trying to assess, and looking at this slide, what the perception of the public is to the in-court proceedings.
Yeah, I mean, I think it's commentary that falls on the sensational side, right? So now it's these people are pandering to the camera, and it's creating a performative experience. So it's turning into like outside the courtroom, like a reality TV show in a sense. Like, I don't like what this person said or that person said. So not informative as to what's happening, but it's sensationalism, and it's just the kind of thing you want to avoid.
So let me play this for you, and then I'll ask a question about
We'll be
it.
live, Matt Johnson alongside my friend Kelly Craft, and today for Ted and Julia. Busy day here. Let's begin this hour in the state of Utah, where the suspect in the Charlie Kirk assassination is due back in court today.
22-year-old Tyler Robinson is accused of murdering the conservative activist during a rally that was held at Utah Valley University. This took place earlier this month.
Robinson is expected to appear via Zoom during that hearing alongside his newly appointed defense attorney, where we're likely going to hear a discussion as to whether or not they want to schedule a preliminary hearing.
While we wait for that hearing to begin, let's go ahead and take a look at a backgrounder on this case. This is Court TV affiliate KSTU with a closer look at the suspect, Tyler Robinson.
Robinson had confessed to them or implied that he had committed the incident.
From his apartment to his family's home, the FBI and police combed every inch of Tyler Robinson's life, his family expressing to law enforcement that he had become more political in the last few years.
Robinson mentioned Charlie Kirk was coming to UVU. They talked about why they didn't like him and the viewpoints that he had. The family member also stated Kirk was full of hate and spreading hate.
Nick, why don't we go ahead and bring in our guest this hour to discuss as we wait for that court appearance to begin out there in Utah. Joining us now from Los Angeles, California, former Deputy Public Defender for LA County, Philip Dubé. Philip, nice to see you on this Monday.
We appreciate the court's comments with respect to Your Honor's role in this case. In like manner, we commit to approach this case with integrity, with professionalism and stability. We are truth seekers. We will aggressively pursue the truth in this case. Thank you. Thank you.
All right, counsel, unless there's anything else, thank you for being here. This court is in recess.
That concludes that hearing. Philip, let's go ahead and bring you in on this.
The only criticism I had was that those closing words about how we're all here to seek justice, like the warriors of justice. Attorneys and judges don't speak that way in open court. It's presumed that everybody will act with integrity, with honor, and to articulate it on the record, in my opinion, is pandering to the cameras.
All right, Philip, so...
You're familiar that one of the criticisms of the court coverage in the O.J. Simpson case was that everybody, including the judge, was pandering to the camera. You familiar with that?
Yes.
And this guy from L.A., he's probably familiar with that case. He's accusing the court and the prosecutor of pandering to the camera. And then the first part of the video, where they refer to the backgrounder, are you familiar with what's referenced there?
Yeah, again, it's kind of going into the background stuff again about evidence, and then jumping in while they're waiting and so on, and then jumping into that.
And who is giving the backgrounder there? What the clip is of Governor Cox, is it not?
Yes, the governor. No.
Okay.
Just, yeah, reading another press conference.
So that's a sort of an incriminating narrative. And then the second part of it is, what is the perception of the public to the court proceedings being televised, and at least according to what Court TV is putting out there?
Oh, that it's a show. It's pandering to the camera.
Pandering to the cameras.
Yeah.
Does that further the reputation of the judiciary, or does it detract from it?
Is it what?
Does it further the reputation of the judiciary, or does it detract from it when the perception is right or wrong? And I'm not in any way endorsing what he's saying, but in terms of what's getting put out there to the public.
I think it creates pressure on everybody to have cameras in here, from the jury to everyone involved. I think this is a very high-profile case, probably one of the more high-profile ones I've ever been involved in. I think there's pressure on the prosecutor, the jury, everybody involved in this case. There are a lot of people watching, including very, the executive branch, everybody's involved. So I think just those comments and everything else is just pressure to me.
But those kind of comments, like a comment that a prosecutor is pandering to the camera, if that gets to prospective jurors, and that prospective juror is sitting in court as a juror and is asked to evaluate the arguments of a lawyer, and he or she already has a preconception that, oh, this is a guy or this is a court that is pandering to the camera, what does that do to the reliability of the fact-finding?
I'm just going to, it is what it is. I don't have anything else to say about it.
Be live, Matt Johnson alongside my friend Kelly.
What was, on the September 29th, what was CNN's sort of capsule of what the hearing was about, the appointment of counsel hearing? What was their headline?
Yeah, so confessions, DNA, and his grandfather's rifle. This is the evidence so far on the Charlie Kirk shooting suspect.
What did confessions and DNA have to do with what was happening in court on the
Nothing.
29th?
And again, this is just, in every hearing and everything you see, it triggers the same information and the implication that this stuff is part of the hearing. So people aren't necessarily watching the live stream. A lot of times in these courts, you're watching the coverage of the live stream, not the live stream itself. You know, like in the survey, not a lot of people, it's like 25% watch the live stream, but people are seeing this stuff on TV, and this is what the media coverage is. So it's not showing the live stream, it's screen captures, it's like a short summary of what happened, and then going into this information and the perception that this was evidence presented in the hearing when it was not.
And the substance of it, confessions, DNA,
Exactly.
is sending a message, is it not?
Yes.
Now, is this, again, on the December 11th court appearance, I want to ask you how Fox News covered it, and with one of their talking heads
Just add to
here.
our comments about his demeanor in court earlier. You know, we talked a little bit about don't try to understand the mind of a monster. We do know a little bit about the mind of this monster, in that I believe he's incredibly proud of his handiwork. It makes us think a lot about Luigi Mangione. These two men inscribed notes on the bullet casings that they used to commit murders, murders that were to send a message. He committed an assassination in a very public place against a person that he had ideological differences with, entirely politically motivated. That is a person who's proud of their handiwork. So I think that when we see him loose and calm, relaxed, and smiling in court, I think that's an outer manifestation of his inner feelings, that he is very proud of what he's done, stands by what he's done, has no remorse for what he's done, and is looking forward to the world watching.
Jonathan, I see you nodding in agreement.
Yeah, I think that's exactly right, as Josh put out. When you have cases of this kind, you are off the map. You are where monsters dwell, to use pirate terms. This is where you find monsters, are in these cases. And you find people that don't think the way you do. This is one of the reasons jurors often stare at defendants whenever they can get away without being impolite. They look at these defendants to try to figure out something not just about them, but themselves. How can someone go off the map to this degree? The evidence here is overwhelming. And a lot of attention is likely to be what possesses a person like this to treat someone like Kirk as a trophy. And that is what happened.
Well, if it's true that he did it and he gets convicted of it, I guess you could say that, you know, he thought in his own twisted mind that it was something that he needed to do, and you could never understand, as you were pointing out earlier, Professor, you know, Trey was pointing out, you know, the person who drowns their children and the person who bludgeons someone to death, you could just never get inside that mind to even begin to understand what's going on.
Is it your understanding?
That's right. I think that's absolutely true.
Yeah, that does it for us here.
You're understanding the first commentator, the first talking head there is an ex-prosecutor, right? And is he sounding like a prosecutor talking about the mind of a monster?
I mean, to me, it's more sensationalism. First of all, again, negative character evidence is some of the most prejudicial pretrial publicity that you can have, emotional, negative character evidence, particularly in death penalty case. and you're hearing mind of a monster, he's a trophy. I mean, he's smiling. Like, what is the basis of any of this? Like, there's nothing from that hearing or anything that is relevant here. Like, this is just pure speculation and sensationalism.
Now, the second speaker, the guy who chimes in and says, yeah, this is, the evidence is overwhelming. At this point in time, had any evidence been disclosed to anybody, either in the court hearing or, as far as you know, anyplace else?
The only thing we've had is a press conference with the charging document.
So the second guy, a law professor from Georgetown in Washington, what would have been the basis for him commenting that there's, all kinds of evidence here, agreeing that we're dealing with monsters? What is the factual basis for that?
I guess from the charging document.
Okay.
Just add to our comments on that.
Now, did you also take a look on that same date of the Fox coverage? And this is from the ex-FBI agent. Is their talking head here?
Yeah, and the sociopath stuff feeds into what we've heard earlier.
Well, my first reaction is looking into the courtroom and seeing what's happening. Again, talking about Robinson, it's disgusting. He's a true sociopath. It's someone who has absolutely no empathy. They have no remorse. They have no conscience. He killed somebody. He doesn't care. He's smiling. But again, that's not going to serve well. When the trial comes to pass and the death penalty is on the table, again, jurors will not be okay with that. The other thing that I think is very important to understand is that working with these victims, I know myself when I was an FBI agent, I wanted a victim-centered approach. Erika Kirk and those in her surrounding sphere, her family, her loved ones, Turning Point family, they are the victims of this. And frankly, the American people who have had to watch this absolute catastrophic tragedy and evil live on television. I mean, it's disgusting, it's heinous, but she has a right to know. And I do think it's very important in this process that you are working closely with the victim, and I assure you that they are. She deserves to know what is going to happen. She didn't wake up one day and become a legal expert and a law enforcement expert. She is the victim of this most heinous crime. And again, God bless her family, and I do appreciate that there are people that will step up to the line and will hold her hand and walk her through this process, as that is what she deserves. There's several other things that come to my mind in this trial, but it does come down to the judge's decision. But the conspiracy theories are despicable, they are disgusting, and you are profiting off of someone who has been murdered. And that is wrong. That is sick. And if you think that you're helping justice to be served, you are wrong. You are doing no favors for the prosecution team. There are solid law enforcement officers on these investigations. Trust that they are doing the right thing for the right reason. Look, I come from the FBI. I understand why people are in a position where they do not always trust the criminal justice system because of things that we have seen in our country. But rest assured, on this investigation, no stone will be left unturned. All eyes are on this, and there will be no mistakes made. And so please do not take the liberty to go and make up and fill in the gaps where you do not have answers. It is inappropriate. You are not helping things. You are making things worse. And if you want justice to be served, you need to let the process work the way that it should and stop putting these lies into people's minds, because you are hurting people, and most of all, you are hurting Erika Kirk, her family, and her loved ones. It is unacceptable. It cannot be tolerated. And anyone that has a clear conscience about making money and creating clickbait, that is sick.
Yeah. Now, what about that segment educates the public about what was happening in court on December 11th?
Yeah, clearly it's not, and it's in the backdrop of you see just, in the corner of the courtroom, but it's just, again, an opinion and a diatribe basically about, there will be no mistakes, no stone will be left unturned, and that the prosecutor's doing everything correctly, and so on. So,
does the literature tell us anything about what impact it has in terms of who the person speaking is? Like, this is an FBI agent, ex-FBI agent. So do people listen? Does research say anything about that?
It's just like a source credibility question. Law enforcement, people know who she is. It's not always the case that a stranger is seen as credible, but definitely when you hear more prominent people saying it, absolutely. And just you think about how people passively consume information. So you're not really, when you have this on, you're not necessarily highly critical of what's being said. It's passive consumption of news, so you're not questioning the source per se or thinking, well, this is maybe not appropriate, none of the evidence has been presented yet. It's editorial masked as news, basically.
I notice in this clip she's critiquing the conspiracy folks from trying to profit from their commercial ventures.
Yeah.
And as she's making this critique, you notice the advertisements running on the side of the video. You get a loan for a car loan.
Yeah.
4.99%.
I mean, it's an ad because it's online. I mean, yeah, there's an ad there for sure. So they're monetized. Is that the point? That they're monetizing it? Sure.
Right. Is that typical of the coverage you're seeing here? In other words, especially on the social media, if you go to social media and try and pull up these clips, you get the clips, but you get a lot more, don't you?
Yeah, I mean, you're always going to get ads on social media. That's how they make money. Are you asking about more like in terms of how, like what surfaces and what becomes viral, or?
Well, we'll get to that.
Okay.
That's a separate issue. Okay. This is the, I'm going to skip
And
that
accused
one.
of assassinating right-wing political activist Charlie Kirk is
Was there also at the December 11th hearing quite a bit of focus on the tie that Mr. Robinson was wearing?
Right. So to me, the thing that stands out is you could see the impact of some of this stuff that's irrelevant. So there was a reference to his tie. It was like trans tie, and then a pro-trans tie, whatever that is, and that becomes a search term. So people want to know more about that, or just following his court appearances and so on. So people are more engaged. They're actively searching, which is different from passive consumption.
Okay.
And just to be clear, I mean, there was an increase. I don't know what the numbers were before, but yeah, there was a significant increase in those searches.
Hey, Mr. Burt, I don't mean to interrupt, but I just want to give you 45 minutes remaining.
Somebody just passed me a note.
All right, good deal. Thank you.
I got it. Thank you.
And the country, even the world, watching as Charlie Kirk's accused assassin made his first in-person court appearance today.
Is this another segment from our body language expert?
Yes.
Where he talks about he didn't see any grief muscle?
Yes. So
What is
apparently,
a grief muscle?
do I know what a grief muscle is? I don't know. So apparently the grief muscle wasn't functioning properly to imply grief by looking at the clip.
And that was the focus of the coverage? It wasn't who got appointed, who the lawyers are, what the next procedural step is, whether he was showing a grief muscle?
Right. So again, we're just back to this conjecture of, well, nothing interesting happened in this hearing, so let's find something interesting to talk about, and it's staring at the defendant and making an assessment of what he's thinking or whether he has grief for what he did based off of his grief muscle, whether it was, I don't know if it was not doing the right thing. I don't know.
Okay. Was there also in this hearing sort of a focus on what a high level of security was necessary to manage Mr. Robinson?
Yes.
And the local KT...
New video showing what we believe is Tyler Robinson's police escort leaving the courthouse in Provo just in the last hour. Robinson accused of murdering Charlie Kirk during an appearance at Utah Valley University back in September. Thanks.
And what kind of message is that sending to prospective jurors?
Well, I think in a case like this, like I could see it creates anxiety among prospective jurors. Like this is dangerous, potentially. Like there's always pressure, on a high-profile case in terms of juror serving, and then adding cameras to the courtroom, risk of somebody being disclosed as who they are, and then you have, news stories about SWAT teams and all these things just to kind of at the courthouse.
And how about the inference here that Mr. Robinson has to be transported in a SWAT vehicle?
Sure, I mean...
In terms of his dangerousness.
I think it's just the nature of this case, of the danger of it.
Okay, we're going to skip that, and I'm going to ask you, did the court coverage then cause responses that sort of are connected with the court appearance? And in this case, you have the court appearance on the 11th, and then 2 days after, is there sort of a responsive appearance by Mrs. Kirk to the events that happened in court regarding whether the defendant should have discovery or not?
Right, yeah.
So was this coverage on December 13th a nationally televised town hall?
It is.
on CBS.
Let me play you just a little segment of that, and I have a question.
What is going on? Why are there so many conspiracies spreading about what seems to be a pretty open and shut case?
This is the first time that we have seen evil on display where we have social media at our fingertips. Something so evil that happened, people are wanting answers immediately. They are wanting to figure out how to wrap their mind around this. Egyptian planes.
Egyptian planes.
Egyptian
Do you
planes.
believe that Tyler Robinson murdered your husband?
Yes, I do.
Why do you think it is so hard for so many people to believe that reality?
Because it's too simple. Again, everyone always has to think there's more to the story. Well, sometimes there's not. I've seen the autopsy report. I've seen our case pulled together. I've been in constant contact with our lawyers, the prosecuting team. I've seen it all. And let me tell you this. Why in the world, why should we, prior to the trial, lay all of our hands and cards on the table for the defense team to see, to somehow then, I don't even know what they would do with it, but what I will say, and I want to get on the Egyptian plane thing, we'll take a flight on that for a second. What I will say is what I'm worried about, and I'm fascinated, just from a legal standpoint, to see how the United Healthcare trial pans out. And I say that because this is the first time where we are seeing the implications.
You're talking about Luigi Mangione.
Correct. I prefer never to say any of their names. They do not even deserve the ounce of oxygen and breath out of my body. But what I mean is it's fascinating to see how social media will impact that court case, just how it might impact mine.
Are you mad as he's not going to get a fair trial?
Well, I'm nervous that there could be, they'll say we can't find a fair jury. Like they're going to taint the jury pool. And in that case,
That's how widespread you think these conspiracies have gone?
yes.
That's how mainstream they become.
Okay. Egyptian planes?
So one of your categories was inadmissible evidence, right? And I know you're not a lawyer, but you're generally familiar with, there are certain things in a penalty phase of a capital case that a victim impact witness can say and certain things they can't say, right?
Sure.
Like you can't express opinions about the defendant, as an example. Why is this sort of coverage prejudicial in relation to her commenting on court appearances and whether Mr. Robinson should have the benefit of discovery and her opinion about guilt and the narrator's opinion about the evidence being overwhelming?
Yeah, so I mean, I think there's a lot there. I think, one, obviously, there's a lot of empathy for the victim's family, and I think that's very appropriate. So she's a credible source, I would say. I think it's not ideal to have a victim saying that due process shouldn't be complied with, the idea of discovery, and why are we sharing, exchanging information, which is the way that due process works. And then the references, I've seen the evidence, I know, it's an open and shut case, essentially commenting that he's guilty and the evidence suggests that, would definitely be prejudicial and create a presumption of guilt among prospective jurors. So it's kind of like, a lot of that, I think the thing about the conspiracy theories, which are, this is not the first time, I mean, if you look at like the DePape case, where, David DePape attacked Paul Pelosi, trying to kidnap Nancy Pelosi, and Elon Musk was spreading rumors about his relationship with the victim and implying they had all of that. So it's definitely not the first time. It's unfortunate it happens, but it happens a lot.
Okay. Now, you have many more examples in these clips of similar things,
Yes.
right? The basic point being, we're not getting information about the court proceedings, educating the public about how the law works, but we're getting a lot of opinions going to the issue of whether Mr. Robinson is guilty or not.
Yeah, and I'm not saying this was triggered by the court hearing. I mean, I get it was in the sense that she's commenting on what happened.
Right.
Yeah, so, sure.
So I want to talk to you about and we're going to skip the other examples because we're running out of time here. Let's talk about your survey.
Okay.
So walk us through that. first of all, what was the methodology of the survey?
So again, this isn't a change of venue survey, but it follows the standard practices put forth in the ASTC, American Society of Trial Consultant Professional Standards. So we're using a random digit dial technique. Everybody has a known chance of being selected, so it's not a text message sampling approach or email or anything like that. It's phone calls, cell primarily.
This is its focus exclusively on Utah County.
Yes, they have to be jury eligible, so they have to either be registered to vote in Utah County or have a driver's license with a Utah County address on it to be included. And then the survey is designed for, initially, you're just capturing general impressions of the criminal justice system to get people familiar with the study. And then we're going, for this one, it's case awareness, like we would do typically, case recognition, prejudgment, just to get a feel of what's the baseline, where we at today in terms of that question, a fixed opinion question. I call it like a presumption of guilt question. Would the defendant have a difficult time convincing you that he's not guilty? So it puts the burden of proof on the defendant. And then where their source of information is, like is it getting it from local news, social media, national news, things like that. And then a couple basic recognition items, how they watched streaming, which was probably, if I did another survey, I probably wouldn't ask it that way, because I think based on what we saw, like people aren't per se seeing streaming of the hearings, it's the commentary and post-hearing stuff that's really coming out from that. Whether they knew about a confession, I think it's probably better text messages, because that's primarily what we're talking about, and a few other things. So
what were the key findings of the survey?
Yeah, so high level, so the recognition rate is pretty much everyone, 99%. This is based off a sample size. It's a smaller sample. Again, this is just a snapshot of 200, not the typical 400 that we would do like in a change of venue survey. And then guilt was high, so 64% believe that he's guilty of murder based off of what they've read, seen, or heard about the case. Only people that answer that question are those who know about the case. The 3 people that didn't know about it didn't answer that. Only 7% reported that he's not guilty. That fixed opinion question, you can see over 50% already believe that the defendant would have a difficult time convincing them that he's not guilty. And 35% believe he should be sentenced to death at this point, and 65% have a somewhat or very negative opinion of the defendant, which fits into all that negative character evidence that we just walked through for the last.
So based on the results of this, would you conclude that there's been so much publicity in this case that it doesn't matter whether we get any more, because the jury is already, or the jury pool has already been so tainted that adding more to it is really not going to change the equation?
So the idea is Utah County is so saturated that you can't get a fair trial here, so just
right.
play
At this
more
point,
coverage?
it's so saturated, the court should do nothing to try and control the publicity, and because it's basically a done deal.
Well, a couple things. One, there's also a lot of media coverage coming out of this in Salt Lake City, which would be the largest county, which is where you would typically move it to. So then what you're saying is, well, there's so much coverage here, let's just have a free flow of sensational, prejudicial media coverage, and then down the line, when it's time for a change of venue, you can say, well, there's nowhere to move it, because Salt Lake City's just as bad, so I guess you're sorry. So there's that as my first reaction to it. And then I think this is the baseline of where we're at. So you still have, like for the death penalty question, it's only 35%. You're not seeing above that 50% mark yet. We don't know, like, a lot of it, a big one is case knowledge. So you might find that recognition rates are high here, and I'm sure they're high in Salt Lake City and everywhere else, but it doesn't mean people identify with the case, went to the university, have personal connections, know all the case-specific facts. We don't know any of that yet.
So in your survey, only 35% of those polled indicated that Tyler Robinson should be sentenced to death if he's convicted?
At this point, yes.
And in terms of whether he was guilty or not, you've got 64%.
Right.
Okay. What else about the survey?
So as you'd expect, people are following the case, so people are following it somewhat or very closely. Sometimes in big counties, those numbers are lower, because you'd expect in big counties there's so much else going on that it takes a lot for a case to capture people's attention, unlike smaller communities where they're shocked and you follow it very closely. Kind of back to the Koberger case in Idaho. And then you can see everyone's talking about it. So 96% reported that they are talking about the case, or they've heard others talking about it in person or online, which also suggests that the big county is taking on characteristics of a smaller community. And you, in terms of source, so 53% are getting the news about this case from social media, and we kind of skipped that, but there's a lot of sensational stuff that's being created, and clips and reels and inflammatory comments and screen captures from these hearings with comments on them as well. And then people have seen something on social media about this case, 69%. And then they've seen something on YouTube, 34%. And then 45% have seen something about the case on local television as well.
Okay. What does this slide show?
Yeah, so just high level, again, this case is capturing this community's attention. Despite the size of the county, 99% recognition rate. That's very, very, very high. I don't see that very often. And they're following it somewhat or very closely already, and nothing's really happened yet. We haven't had a preliminary hearing. We haven't had the big things happen. We've had pretty procedural-esque hearings about, counsel in terms of gag orders and things like that, and they're already following it closely before the really sensational stuff starts coming out.
Okay. I think this is summary of what you've already said, correct?
Yeah.
So you mentioned this before, but in terms of where people are getting their information from, are they picking this case up from watching live stream or through other sources?
They are not. So if you go back to the prior slide, which is from the survey, this is specifically about the case. They're picking it up from social media, local television. Those are the big ones. They're not watching the live streams, and I think it was like 25% said they've seen like a clip or part of the live stream, but they're seeing news footage on local TV, which we already went through, that has prejudicial commentary about these hearings, whether it's the body language expert or the lip reader or any of this stuff. All that stuff is coming out in those sources, and that's what they're seeing.
Okay, I'm afraid I'm going to have to stop here. I hate to do it, but I have to. So,
Turning to the state for cross.
do you want this up or no?
I think so. Good afternoon, Dr. Edelman.
Good afternoon.
You mentioned that in your employment, you work as a trial consultant.
I did.
And with respect to that, it's more of an advocacy-related position.
When I'm wearing that hat, yes.
When you're wearing that hat. And this hat, you're more of an objective witness.
Absolutely.
Correct. We've talked a lot about today, you've talked a lot about today, we've seen some slides about the negative pretrial publicity towards the defendant. Mm-hmm. Did you research negative pretrial publicity towards Charlie Kirk?
I'm familiar with it, yes.
Did you research it as part of this assignment?
No.
This employee? Did you do any research with respect to negative pretrial publicity towards Erika Kirk?
Towards who?
Erika Kirk.
I did not.
Are you aware of the negative publicity that's out there?
I'm aware of the awful conspiracy theory stuff.
Okay. What about, did you research negative trial publicity towards the prosecution's case?
I've seen what that stuff is, and most of it is not from what would be considered mainstream sources. You're talking about people who support conspiracies all the time about windmills killing whales, and that Winston Churchill was the true villain in World War II, so I don't put much stock in that kind of stuff. I know it's out there. I don't think it's comparable.
Okay. What about pretrial publicity, positive pretrial publicity towards Mr. Robinson? Did you look into that?
No, and there's social science literature on that positive pretrial publicity does not mitigate or eliminate the effects of negative pretrial publicity.
Are you familiar with Professor Christine Ruva?
That's her research?
Her research?
Yeah.
Because she would say otherwise, wouldn't she? That positive pretrial publicity towards a defendant would tend to mitigate?
Positive mitigates? You're saying she says that?
Sure. That positive pretrial publicity towards a defendant would tend to mitigate guilty verdicts.
There's very little pretrial publicity that tends to be positive, and from my experience and what I've seen, no, it does not. You have a mountain of negative pretrial publicity, and you might have 3 stories that are positive. That does not mitigate a mountain of negative pretrial publicity.
Okay. But it would depend on what that juror was exposed to, correct?
Well,
What he or she
again,
paid attention
most
to.
of the pretrial publicity in cases like this is negative, so if you're implying that it's balanced, I would say absolutely not.
Okay. In your survey, I'm going to turn to a few of these questions. I believe it's number 2 in the binder there that you have.
Yeah.
The question was asked, question 6A, if you want to go to that question.
Give me 1 second here. Which tab is it? Sorry.
I think if you go to number 2, tab number 2.
Okay, got it. Which question?
6A.
6A. What 3 words best describe Charlie Kirk?
Yes. You identified, there were a number of respondents that had a negative attitude towards Charlie Kirk.
Sure,
in
I
your
think so.
survey, correct?
I think that's fair.
For example, multiple people referred to him as a racist, correct?
Okay.
This is your survey.
Yeah.
Do you-
Again, the question above that is 64% or so have positive opinions of Charlie Kirk. So you can cherry pick comments in there, but in general, overall, people have positive opinions of him in this
But
community.
there are people within this community that have a negative attitude towards Charlie Kirk.
Yes, I'm
Correct.
sure, and nationally.
Okay. He was called inflammatory in your survey, correct?
Inflammatory?
Uh-huh.
Which comment? Oh, that's what someone said?
Yes.
Okay.
As a misogynist?
I'm not disagreeing with you. You could cherry pick as many as you'd like.
Asshole? Harmful?
Mm-hmm.
Did people respond like as if he were that he's a bully? Did you see
Okay.
that? A bigot?
Okay.
Homophobe or homophobic? Multiple people put that.
Okay.
Divisive? Prejudice?
Sure.
Evil? On the other hand, you asked what 3 words best describe Tyler Robinson, correct? And that was question 5A.
Yes.
And isn't it true that a number of people responded with not guilty or innocent until proven guilty?
Sure.
Okay. We would like people to respond that way, correct?
I what?
You would like someone to respond that way.
They can say whatever they want. Again, this isn't a change of venue survey. This is just measuring awareness of the case in where we're at today.
Okay. Multiple people responded with respect to what 3 words best describe Mr. Robinson as scapegoat, correct?
Multiple? Out of the 200, how many you got there that say that?
More than one.
More than one?
At least more than one.
I can see plenty of confused, radical, guilty, mentally incompetent, messed up person, lost, confused soul, very confused. I mean, I'm sure there's a array of many different things in there, from mental illness to evil to...
Let me take you to page 21.
Page
Of
21?
your survey, correct.
Next to, okay.
Do you see scapegoat about maybe a quarter of the way down or so?
I see piece of shit, sad, so bad, selfish, guilty, suspicious, troubled.
What about scapegoat? Do you see scapegoat?
I do.
Okay. A few lines down, maybe 10 lines down, do you see scapegoat, victim?
Scapegoat, victim, okay.
Okay. That would imply that some of these conspiracy theories out there are taking hold of people within this community, correct?
Among the, I'm sure there's people that believe that. I never said there weren't, but I don't think that outweighs the majority of people who think he's guilty and all the other awful things. And remember, Charlie Kirk is not the one on trial in this case. It's not going to be about whether Charlie Kirk is guilty or whether he should be, what that punishment should be. It's about the defendant. So in the majority of opinions towards Charlie Kirk in this community are positive. So there are people that have negative.
Okay. Would you agree that negative publicity towards a victim has an impact on prospective jurors?
Not in the guilt phase, maybe in the sentencing phase.
Not in a guilt phase?
Not in the guilt phase. I don't think that whether or not they have a positive opinion of the victim implies whether or not the defendant is guilty.
I mean a negative opinion towards the victim.
Towards the victim?
Yes. Does a negative opinion towards the victim
does that mean
play into the mind of prospective jurors when they come in?
So if someone thinks that Charlie Kirk was a divisive figure because of what he said publicly, that the defendant's not guilty?
Sure. Well, could that have an effect on the verdict?
I don't think it will in this, no.
Okay. What does the literature say?
I don't know of any literature that would fit that scenario.
Okay. Question 6B asked about whether someone has what's your opinion of Charlie Kirk? Two of the potential responses was somewhat negative and a negative opinion.
Right.
25% of the people in our community in this snapshot have a negative opinion towards Charlie Kirk, correct?
63% negative, 25%, or I'm sorry, 63% positive, 25% negative.
So 25% negative. Thank you.
And just clear, I'm not saying change of venue.
Objection. Non-responsive.
Doctor, this is not where you get to make statements. You can respond to questions, and that's something we do to make sure it's balanced. So I'll ask you to respectfully do that.
Now, question 2A reads the following. Now, I'd like to ask you about an upcoming jury trial in your community. Back in 2025, Charlie Kirk was shot and killed during an event at Utah Valley University in Orem. Tyler Robinson was later arrested and charged with intentional first-degree murder. Have you read, seen, or heard anything about this case?
Yes.
You asked that question.
Yep.
And that's where 99% of the people, there's case awareness, 99%, right?
Right.
But that question doesn't really help us with respect to can Tyler Robinson get a fair trial in this community, correct? Case awareness?
I didn't ask that question. That's not the purpose of the question. The purpose of the question is to identify what the recognition rate is, how many people are familiar with the case.
Okay.
That's the purpose of that question.
Okay. So it doesn't relate to whether or not he can get a fair trial. People's awareness of it.
Don't think I said that.
Okay, fairness. That's fair. Dr. Edelman, what is your understanding of the purpose of this hearing, of the motion in question here today?
To the question being towards whether or not there should be television cameras in the courtroom.
And why does it matter if there are televisions in the courtroom where there's pretrial publicity?
Because it creates sensational, misleading media coverage that undermines the defendant's fair trial rights.
Fair trial rights?
Yes.
Okay, because of the media coverage. That's why we're here. And isn't it about impaneling a jury that could sit in judgment on Mr. Robinson? Isn't that the ultimate question we're trying to get to?
The ultimate question is, can he have a jury who has not been prejudiced and comes in with preconceived notions of his guilt that don't have case-specific knowledge, that as the trial goes on is stimulated and activated by hearing new information? There's a difference between a jury that in a community that doesn't know the evidence and hears it for the first time and maybe convicts a defendant, and a jury that comes into a courtroom somewhere else and all the information confirms what they already know and they convict the defendant. The outcome's the same, the process is very different, and that's the problem.
Okay, so it comes down to, can he get a fair trial with a jury here in Utah County?
In Utah County? Again, I'm going to keep saying this. This is not a change of venue survey. I didn't recommend for a change of venue. My limited purpose was to assess where people are getting information about this case. Are they following it closely? What sources are getting it from? And are they developing negative impressions and a presumption of guilt? And this stuff here we're talking about, this data are the baseline, and the question is, it going to get worse, or is it going to stay here?
But we end up at the same point. Can we seat a jury to to sit in judgment on Mr. Robinson? Can he get a fair trial?
Not based on this. Maybe that comes down later after, when we're closer to that. The question that this survey was designed to measure is, where are people getting the source of their information? Are they seeing prejudicial pre-trial publicity? Are they following it closely? And what impact it's had so far? And what's the baseline? So leave cameras in the courtroom, and then you get more of the stuff we just walked through. And then the preliminary hearing comes out, and then witnesses testify, and all of that prejudicial stuff comes out. And then there's more negative pretrial publicity. And now we're back here in 6 months or a year or whatever it is, and we are talking about change of venue because everybody in this community has been saturated. And the numbers you see in the survey, like guilt, is now 70-80%, and prejudgment on sentence is over 50%, and everybody knows prejudicial details. That's what we're trying to avoid.
Fair enough. But the ultimate risk that we're getting to is whether or not we can seat a jury here. That's why we're asking these questions about what are the effects of cameras in the courtroom.
I disagree with that. I think you can always find 12 people in any venue to raise their hand and say, yes, I could be fair and impartial. If you look at Rideau v. Louisiana, it was the most prejudicial confession the Supreme Court could imagine. It was recorded in the sheriff's office, put on TV, and all those jurors, 12 of the jurors, all of them said they could be fair and impartial. 3 of them had seen that confession, and the Supreme Court said no. So just getting people to say they could be fair and impartial, I see it all the time. I do it as an advocate when I do jury selection. It's a common thing. It's easy to get people to say, I can set it aside. That doesn't mean they can, and there's no evidence in the social science literature that supports that they can, particularly when they have case-specific knowledge. But you can definitely explain to them the law requires you to be fair. Can you set it aside? Yes. So yes, you can find 12 people here or anywhere else to do that.
Thank you. Question 3AI, if you could take a look at that.
Sure.
This is the question about, you referred to this earlier on direct. Given what you have read, seen, or heard about this case, would Tyler Robinson have a difficult time convincing you that he is not guilty of intentional first-degree murder? You asked that question, correct?
Right. So it's based on what, yes.
Now, you would acknowledge that this question shifts the burden to Mr. Robinson, that he has to prove his innocence.
Oh, I'm sorry. Which one? Oh, you're talking about, yes, I'm sorry, 3AI. Yes, so that is a question that a judge in Tennessee came up with. Yes. And it was a measure because people would say they could be fair and impartial. In the jury selection, they expressed bias and said they could be fair. And then he said, well, could you put the media out of your mind? Or would the defendant have to prove that he's innocent? They go, oh, yeah, he couldn't change my mind. But yes, so it was an inconsistent answer. I thought it was an interesting question, and it correlates better with other variables in surveys than can you be fair and impartial. So I use
But it does shift the burden to the defendant.
Well, for the jurors,
that question.
they think it shifts the burden. It's not telling them that burden is shifting. I don't think the question shifts the burden. I think the question is, would people already hold the defendant to that burden?
Okay. And it's your experience that that question was asked in Tennessee?
That question correlates with things like case knowledge, strength of opinion, and all these factors that you would expect the question to correlate with if it's a valid, reliable question. In contrast to, can you be fair and impartial, does not correlate with any of those things. So people with a lot of case knowledge are just as likely they could be fair and impartial as people who don't know anything about the case. So that would be considered a questionable, like the validity of that question is problematic.
Okay. Take you to question 7A.
7. Yes.
The prosecution is seeking the death penalty for Tyler Robinson. If Tyler Robinson is found guilty of first-degree intentional murder, which sentence do you believe he should receive, the death penalty or life without the possibility of parole? Are you familiar that before, if Tyler Robinson is found guilty of aggravated murder, which is the actual name of the charge here,
sure,
it would then go to a sentencing phase.
Right.
On a question
familiar with that.
Of death, correct? And you're familiar that the jury would be instructed that they would be required to weigh both mitigating and aggravating circumstances.
Is this a weighing state? So it's weighing the two? Okay.
Before deciding on the question of death or life without a possibility of parole, correct? Is there a reason why you left that fact out, that the jury would be told that they would have to weigh mitigating and aggravating
Yeah,
circumstances?
so again, this is a snapshot. This is not, it's, for example, I wouldn't read an instruction in a survey about the presumption of innocence, and there's like, if you look at the ASDC standards, you're not supposed to do that. This is where people are at today. It's a snapshot of their bias. It's not, oh, I think you should get the death penalty, but you'd now explain the entire system to me, so I've changed my mind. I don't think you should get the death penalty. So,
Well, isn't it true that if you were to explain to them that there's mitigating and aggravating factors to be weighed, that the number of people who would support the death penalty that would respond yes on this question would go down?
why do you say that?
Because you would have explained further process.
So explaining the process means that they change their opinion? Do I then have to...
If they were instructed in this question that they are to weigh mitigating and aggravating circumstances before coming to a conclusion,
the question
wouldn't that tend to depress the number of people voting for death penalty in this snapshot?
I think you'd get invalid data potentially. First of all, you'd then have to explain how to do that. You'd have to explain, well, they don't know what the mitigators are. Then you'd have to ask, like, death qualification questions. Well, I think I could consider mitigation. Okay, under what circumstances? Oh, if it's self-defense. Okay, well, now let me ask you another question. What about a case of intentional first-degree murder? Could you consider life then? Well, no, now I can't. So all of that stuff you'd have to include, which creates complexity, and that's not the purpose of this survey. This is not jury selection. Survey is not designed to be jury selection. It's not designed to be death qualification. It's where are people at today? And people have opinions, and that's what this is capturing. This person has an opinion that he should get a life sentence. This person has an opinion that he should get a death sentence. That's based on what they've read, seen, or heard about the case. That's what I'm measuring.
Understood. But important critical details are being left out before someone would be charged with making that decision, death or life without the possibility of parole, correct?
I mean, that, again, if this was like a change of venue survey, maybe I would say, like, here's an important mitigator that's coming out, and then when the juror says, like, I think you should get a life or death sentence, ask a question about a mitigating factor and see if they could consider that or if they could weigh that. But that's not the purpose of the survey. And maybe if it comes to that, those are things that you would typically put in those kinds of surveys. But that's not the purpose of this.
Are you familiar that in the state of Utah, if someone is convicted of aggravated murder, that there is certainly the possibility of death, life without the possibility of parole, but also 25 years to life with the possibility of parole? Are you aware of that third option?
I wasn't, but sure, okay.
Should you have put that, had you been aware of it, in your questionnaire, in your survey?
I mean, I think most people would be, from my experience of doing these and getting, the bigger thing is people are fearful that life without the possibility of parole is not actually life. And they're worried that that person will get out. So giving them an option to have a shorter sentence, I don't think is going to reduce death penalty numbers. It might take the life without the possibility of parole, and some of those people might say life for 25 years. But I don't think someone with death is going to say, no, I think I would just give them life, 25 years.
Okay, but it's another option that probably should have been included.
You can, sure. I don't know if I would, knowing it. I still, maybe I would just say life, or life without possibility of parole, or perhaps.
Okay. So you've talked about how surveys like yours, they're snapshots in time, right? And surveys can't predict future conduct. Is that fair?
Well, I mean, it depends on the survey. Like, some surveys may, like, if you ask people about if they're going to vote in the next election, and there's data there, it could predict whether they're going to vote or not, or something like that. It just depends.
Okay. But you would acknowledge that your survey here, it's a snapshot of people's awareness and feelings in the community today.
Yes.
It doesn't represent real-world experience of what a juror would experience if they were summoned to jury and selected to be part of this jury.
So does this survey capture how a juror will react as a juror?
If they were to hear the evidence in a court of law.
No. I mean, I would think of this more as a snapshot of the community, and then what the social science literature tells us. So we know, for example, people who have a lot of case knowledge are much more likely to convict and
process information to be consistent with how they see the world. So if they already think he's guilty and they already know all the evidence, they're more likely to interpret the evidence in a manner to support that position. So we do know that. So you can kind of look at extrapolate from the survey data in that manner. But it's not designed to predict, okay, this means these 12 jurors will disregard the evidence and acquit him or convict him or anything like that. That's not the purpose of the survey.
So the purpose is quite limited in reality.
I don't think so at all. That's your opinion, I guess. I'm sorry.
But it doesn't predict future behavior.
The survey is designed to see where people are at today and make an assessment of whether or not cameras should be in the courtroom or not. And you're talking about like a change of venue survey and whether jurors will be fair and impartial in a year from now or what have you. I don't quite get the connection of how that question is tied to whether there should be cameras filming things and then making speculative conjecture about whether someone's grief muscle is flexing in the right way.
So let me ask a question. I've asked this various ways. What's the risk of cameras being in the courtroom if it doesn't ultimately turn on seating a fair and impartial jury to sit in judgment on Mr. Robinson?
So what is the risk of inundating the jury pool with highly prejudicial, sensational media coverage that characterizes the defendant as guilty, a monster, a psychopath, a sociopath, and so on? What's the risk of that? I think it undermines that juror's fair trial rights. And I think there's plenty of case law where even when juries have been sat and they've served and there's been a conviction, those have been overturned based off of the pretrial publicity. So obviously there were 12 people in that trial that went through jury selection, were determined that they could be fair and impartial, were able to listen to the evidence and reach a decision, and then state Supreme Courts, United States Supreme Courts, has thrown those convictions out based on prejudicial media coverage. So clearly there is an issue, and the question isn't, can you find 12 people somewhere in the county that will raise their hand and say, I can be fair and impartial? I don't think that's the standard.
Thank you, Doctor. You mentioned that these were randomly selected respondents. Digit dial, I believe you said. Did you add any numbers to your survey? Were these all truly randomly selected?
I'm sorry, adding numbers.
Did you add any numbers to be called as part of your survey?
Be called?
Yes.
So the survey vendor deals with the sampling. So I give them the county, and then they buy random sample. And then what they do is, so it's called replicates. So let's say they buy X thousand phone numbers, and they have to work maybe like 100 numbers, and they have to call each one like 3 times, different times a day, and all that stuff until they can reach a resolution like, no one ever answered, or it's a bad number, and then they have to open up other replicates.
Okay. As part of your survey, did you ask whether the respondents had any involvement with this case?
Involved in the case?
Like media, law enforcement, anything like that? No. Okay. Did you ask whether they had a relationship with anyone that was involved in this case?
No.
The respondents?
No.
Okay. What screening procedures did you take?
I'm sorry?
What screening procedures did you take?
So the screening procedure is based off of age, right? They have to be over 18 years of age. They have to be able to speak and read English. They can't have a felony. They have to be a citizen of the United States. They have to be registered to vote or have a driver's license with a county address on it.
Okay, thank you. A few more questions about your survey questions. In question 8A, will you turn to that?
8A, yes.
You asked, have you read, seen, or heard if President Donald Trump expressed an opinion about whether Tyler Robinson should receive the death penalty or a life sentence without the possibility of parole?
Yes.
Killing Charlie Kirk. 81% responded no, correct?
To that one, yeah.
Okay. Question 9, you asked, have you read, seen, or heard if any other public officials have said that Tyler Robinson should receive the death penalty for killing Charlie Kirk, correct? And 65% responded no, is that correct?
32% yes, 65% no.
Okay. Question 10A reads, have you read, seen, or heard if Tyler Robinson confessed to shooting Charlie Kirk? 56 responded no, correct?
Yeah, and I think that's a poorly written question because I think the bigger question is more about text messages than when I wrote it, I hadn't seen all the media coverage yet, and I think confession usually is like the person verbally confessed, and this is more about text messages. So if we do another survey, I would probably change that, the way that question is phrased.
Question 10B. Have you read, seen, or heard if Tyler Robinson's DNA was found at the scene of the crime? 65% responded no. Correct?
Yeah, I mean, I think your point is great in that we're not at a point where everybody knows all these prejudicial details, and we haven't started yet. These are the numbers of the baseline, and the idea is to prevent these numbers from going up. I think that's ideal for you and the defense and everyone, is for jurors to be not aware of all the details and facts, and that they base their decision on the evidence, not what they've heard in the media. So having low numbers on these things is a good thing.
Okay. The media that we watched on your direct examination, almost none of it was live streaming from the court proceedings, correct?
Correct.
It was third parties' commentary on the case. Correct?
Which is what worries me, not the live stream where very few people are watching.
Sure. But that's correct, right? What we were watching commentary on the courtroom proceedings.
Right, so they're taking video from the courtroom or images and then telling the story of what happened at that courtroom proceeding using the images or the lip reader to tell you what the defendant said or his body language based on his movements and all those things. Yeah, so that's what worries me. It's not a neutral, sterile, here's the live stream, no commentary, come here if you want to see what's happening and take away, so you're educating the public. It's here's an opportunity to create sensational media coverage out of all this stuff.
For the person who wants to actually get accurate information, what's happening in the court, where is the best place for them to go?
I mean, to me, it's like we got accurate information for decades without live streaming. They're called journalists, and they would come and they would write stories, and we'd read about them and hear what happened. We don't need to create a circus-like atmosphere or reality show out of a trial.
What's the primary source that they would go to for accurate? To accurately see what's happening in the court, where would they go?
For who? What are you asking?
For the average citizen who wants to follow the case.
Well, I mean, that's complicated. So, like, a lot of people get their news on social media, right, or podcasts, but that social media is also sharing information and content from traditional networks that now have to create more sensational content instead of maybe more quality content because you have to get clicks and based on an algorithm that's like focused on sensationalism and reactions. So you're trying to create content to get attention there. So,
but that person that wanted the most accurate depiction of what's going on in court would be to come to court, correct?
To come to court? That would be great.
And watch the proceedings.
I guess. Sure. Yeah.
Well,
yeah,
that's where it's happening, correct? Yeah. And short of that, a live stream would also provide that if someone tunes into the live stream.
If it was live stream with nothing else, because you basically have about 25% or so or less watching the live stream. So, and the other interesting thing, if you look at the live stream, it's a forum. All these people are coming to it and just spreading misinformation and conjecture about conspiracy theories and you should get the firing squad and all these things.
And those are third parties that this court can't control, correct?
That's on the live stream. That's not on third parties. That's just if you looked at, like, I think it was like Court TV, just the live stream of it, and you watch waiting for the stream to start or during it. It's just a forum of just spreading information that is not accurate, I would say. I'm sure we'd all agree if you looked at it, it's not accurate. But again, like, it's not like the majority of people are coming. If you balance it and you said, okay, well, 80% of the people are getting their information from the live stream, that's great, and very few people are watching all this sensational stuff, so the costs outweigh the benefits. But that's just not the reality. The reality is most of it is sensational media coverage that's being created from the live stream video, and then you get what we saw. It's not like people are coming to the courtroom or watching neutral live stream and then, wow, I learned so much about the courtroom process today. That's just not what's happening.
But it's not the live stream video that's causing this content by third parties.
Well, how would
pushing it out, correct?
How would the content exist otherwise? The video of it. That is the source of the information. It's take the live stream video, and then rather than reporting on what happened, we'll say, like, all this evidence was introduced in the hearing today, which is false. It wasn't. And it creates the impression that there's all of this prejudicial evidence, which is not evidence, and no one's ruled on any of that stuff, in these hearings, when that's not what's happening. So people are being misled. They're not being given accurate information.
Okay, but that's created by third parties, not this camera that is behind me live streaming this proceeding today, correct?
I guess. I mean, I don't really get the point.
What do you mean you guess?
I don't quite understand the point. So you're saying, yes, there's all this prejudicial stuff is coming from the live stream, and it's creating all this prejudicial media content, but it's not from the live stream? It's not that guy over there?
A third party is taking the live stream, which is the accurate recording of what's happening today, and then they're taking that and creating something of it, correct?
So they're taking accurate information and then distributing widely misinformation. So a small percentage
That's
is the accurate
what you're
information.
suggesting.
That's okay. I mean, yes, I think if you just watched the live stream and there was no commentary on it, and in a perfect world, none of those things happen, then yes. But that's not the world we live in. And if you say there's no limit on the third parties using it, then that kind of defeats the purpose of the idea of just having a neutral live stream.
Okay. And to your question, have you seen any video footage or video clips of the courtroom proceedings from Tyler Robinson's case, for example, on Court TV, YouTube, or social media? 74% of the people responded no.
Well, that's my point, is they're not watching the live stream. They're watching the news reporting on the live stream, like on TV, like all the stuff we just walked through.
Exactly.
That's the stuff they're seeing about what's happening. They're not watching the neutral live stream. They're not just saying, here's this sterile live stream of what happened today. They're watching this stuff. That's the stuff they're seeing.
Okay. But again, it's not the live stream that's creating that negative content.
I feel like I'm just going to keep saying the same thing, so, okay.
Yeah. Okay. Just one moment, Your Honor.
Yes, counsel.
Nothing more from the State Judge.
Mr. No further questions, Your Honor.
All right, may this witness be excused?
Yes.
All right, thank you, Doctor.
I'm all done? Thank you. You want me to leave this, sir?
Yes, please. Judge, in terms of a time allotment, I have discussed with the state that they are not going to take their 2 hours. So I don't know how that would affect my time limits, if at all, but I just wanted to let the court know that. I think their witness is going to be very brief.
All right, I see. Well, to the parties, what are the thoughts if so you were